First presenter is Ms. Kathleen Butler. We're so happy that she's come back for the second year. Ms. Butler joined the American Society of Notaries as its executive director in 2001. She is a 36-year veteran of professional association work, having served with major state and national associations for such diverse industries as insurance, telecommunications, manufactured housing, and most recently, Notaries Public. Please welcome Kathleen.
Thank you, Deputy Secretary. Hi, everyone. It's so great to be here with you, and that was a really great thing you did to ask the group what kind of experience you all have as Notaries Public, because yes, this is a fundamentals seminar, but first of all, I really hope that today we're able to help those of you who are brand new to this, or even sort of new to this. Oh, thank you. I need this, to really get on the ground and moving forward with performing notarial acts through the conversation we're going to have today. I'd also like to suggest that even the really experienced notaries who have been notaries for a long time, if you can walk away from this conversation today with a new way of thinking about the fundamentals of notarial acts. I mean, you're experienced, you've probably done just dozens and dozens and dozens of acknowledgements and oaths, which are the two primary notarial acts we'll talk about today. But I want to really get into what the fundamentals are, why the fundamentals matter, and have you think about the solemnity of what you do, why it's important, why we have to protect the fundamentals of the notarial act, because they have served the public for centuries. And notarial acts have been essentially the same in formalities from the beginning. And you're out there performing them, and I really hope that you love what you're doing as a notary, and that we can, again, have you thinking, about feeling a lot of pride in what you do, because it is very, very important. So today we're going to talk about the why, what, and how of notarial acts. And let's see if I can... I was going to make a joke about user error, and I didn't have to. I already skipped the slide. We're going to talk about the why, what, and how of notarial acts. As I mentioned, we want to talk about why notarial acts are important. The what of notarization involves your required or essential tools. We want to talk about standards of professional conduct. If you haven't thought about that in a while, that's going to be really good information for you. We want to talk about the level of liability that you have as a notary. It's considerable, and we'll talk a little about that. And when we get into some of the detail of notarial acts, because of the limited amount of time we have, we're going to really focus on the two notarial acts that you will have requested the most from the public. And of course, that's an oath affirmation notarial act and the acknowledgement. And finally, after talking about all of those principles, we're going to kind of park ourselves on procedures for performing notarial acts and really kind of unpack a process of performing notarial acts that hopefully take it to heart and think about those steps. It will help you perform those acts competently and confidently, because again, you have a lot of liability. You have people who are really counting on you to perform those notarial acts so that they stand up and that exactly the assurances that they are meant to provide are provided through your actions. So hopefully these proven procedures will be a big benefit to you. One comment that I want to make is about the fundamentals of notarization applying to all Texas notaries. And the Deputy Secretary mentioned that later today we're going to be talking about electronic notarization and remote online notarization. And one of the beauties of the way that Texas's notary statutes have been amended is there was a regard for the fundamentals of the Notarial Act. Whether you are a traditional notary public or you're one of the pioneers who decides you want to be an online notary public and you obtain that additional commission, the fundamentals of a Notarial Act remain unchanged. All the principles of notarization apply. Both a traditional notary public and an online notary public are subject to subchapter A of the government code, which is all about traditional notarization and traditional notaries public. Both are also subject to the standard provisions of the administrative code. both notaries under those commissions may perform all notarial acts authorized in the government code. It's just that one notary has the traditional means of performing those acts, and the other notary is doing the same functions, but performing them in a somewhat different way. Under the traditional notary public, that individual can perform notarizations on paper and electronic documents. The key is the signer must always be physically present. An online notary public is, again, performing all those formalities of notarization, except personal appearance is satisfied by remote appearance over audio-video communication. Those notaries cannot perform a notarial act for a paper document. They can only perform electronic notarizations. At the end of the day, I hope you realize that even though we have these two commissions and these notaries can perform these acts in different ways, we've established that a notary is a notary is a notary, and I want you to come to love the solid foundation that those fundamentals will give you. See if I can. I just have like powerful thumbs. So let's see. I think I'll flip. There we go. So the why of notarization. We want to talk about why notarial acts matter, and it's very simple. There is no other ceremony that provides the assurances that a notarial act provides to relying parties. Never take for granted even the simplest of notarial acts you provide. First of all, that document will travel places you might never imagine. Your notarial certificate, I like to call it the living evidence of the fact that you were acting as that impartial witness to that transaction and the official who could certify to the facts in the document, in the notarial certificate. That's one of the assurances. A notary participated as an impartial witness to the principal signer's awareness and free will in carrying out that transaction. Relying parties want and need that for so many important transactions. You're the individual who can do that. That's one reason your notarial acts matter. The other reason is the power of your notarial certificate. Never take your certificate casually or for granted. It is prima facie evidence of the facts that you've certified to in that certificate. That means those facts are taken on their face. They would have to be rebutted for them not to be taken as genuine. That's your notarial certificate. You did that. You completed that. You certified it, the facts in it with your signature and your seal. It's important. And those facts are, of course, the notarization date and the place with the venue, the fact that the signer was positively identified. You're certifying to that in that certificate. You're naming the specific act performed. Again, you're providing evidence of your authority to do this and to certify to those facts with your signature and official title and your official seal. Those are very important assurances to relying parties. And finally, this other piece of assurance that is mission critical, and it's one reason that notarizations are still so valued today, is that notarial acts are recognized across state borders. We get a lot of questions from notaries in one state who will say, I'm a little worried that if I notarize this document for these signers, for this individual, that they can't use their document in the state that they mean to use it in. Well, we have a principle and laws called interstate recognition, and these laws assure that the notarial act performed by a notary in one state is recognized as valid by a receiving state, as if a notary of that state had performed the act. And that's really profound when you consider that notarial statutes and laws and rules have quite a bit of variation from state to state. They differ. But it doesn't matter that there are some differences in notarial law. Again, getting back to those fundamentals, you're performing certain formalities of the notarial act that are constant and true and have been there from the beginning of time. So again, your acts are recognized wherever the document will go, and I think that that's a very powerful statement about what you're able to accomplish with a notarization. I did it that time. I think that's the right one, and it is. So, still dealing with the what of notarization. You do have some required tools, of course, that you have to use, and it's really as evidence of the authority of your office. You're required to use the seal of office, and of course all of you. I'm just kind of curious, you may use a stamp or an embossing seal. How many of you still use an embossing seal for some of your acts? Well, good for you. I mean, it's interesting because most everyone will use a stamp, but who doesn't love the formality of an embossing seal as well? And there are jurisdictions that look for that, so it's always interesting to see who is still willing to use that wonderful tool. You're all required to keep records of your notarial acts in a record book. Now, a traditional notary can keep records in a tangible or paper format, or they can keep those records in an electronic format. And that's very helpful to you. There are no prescriptive rules about what the format of the entries have to be, as far as, there shall be numbered entries and page numbers. It's really, you're allowed to use the format that works best for you in keeping those records, and it can be paper or electronic. Now, one suggestion I will make to you, if you utilize a tangible paper record book, it is helpful to use one that has pre-printed sequentially numbered pages, pre-printed sequentially numbered entries, because your record book could become subject to some kind of tampering, at least when you have a soft-bound or a hard-bound record book that's paper that has these things pre-printed on there, and the pages are secured in a way that makes it evident if somebody pulled a page out. It is a level of protection against tampering, so you want to keep that in mind. But at the end of the day, it's record keeping in the way that works for you, and the most important thing is that you follow the requirements for what goes into the entries, and we'll talk about that a little later. This is something I question, this last one, that many of you are aware of, and there is a statute that says that notaries, or actually it's any state officers who charge fees for their services, need to issue an itemized bill in order to be paid for those services. I have the statutory cite somewhere and I'll share it with you, but it causes me to suggest that a Texas notary would do well to have the means to produce an itemized bill and keep a receipt book for the fees that they charge. Now, of course, you want to record the fees that you charge in your record book, so that record book serves as that instrument for recording that information about fees. And you also are required to post a list of fees in your place of business. And that's very helpful. And what's even more helpful, if you are outside of your place of business, I recommend that you have pre-printed loose copies of a fee list that you can hand to your customers. It's in the spirit of the law that requires you to post them at the office, so it's certainly helpful if you can do that. And it's just another way that you're showing your conscientiousness and attention to detail in notarizing. So this is a really important what of notarization, and I alluded to it a little earlier, and that is standards of professional conduct. Our statutes cover, generally, and I'm speaking about statutes all across America affecting notaries, there's a lot of how to and what to. We really need more statutory and rule treatment of standards of conduct. It's the type of attention to detail that can really help elevate the office. And it also, with you paying attention to standards of professional conduct that aren't necessarily mentioned in your statutes but are widely accepted and recommended, it's a great tool for helping you avoid liability, serve the public well, and avoid having questions later about your ethics and your intent when you served. So, of course, you always want to act lawfully and ethically. Lawfully is pretty simple. I encourage all of you to go to your state statutes and take the time to really read the codes that apply to notaries public. You also have a very comprehensive set of administrative rules. most of us know what those are. Administrative rules provide another layer of interpretation and regulation to the statutes. Usually rules have to be authorized in the statute for a given subject matter, and then the entity or the individual who has authority to write the rules can then create them. Together, that makes a very powerful set of guidance for notaries. And so you really want to be familiar with, again, the statutes that govern what you do and the administrative rules. This one's really important. So many notaries, maintaining commission information and status. You went to a lot of trouble to become a notary, you're here today trying to learn how to be a really good notary. You have the tools and the record book, and you've performed notarizations. It's very, very important that you maintain the lines of communication with your commissioning official, the Secretary of State, as far as your current name, should that change, your current location, should that change. If some circumstance arises where perhaps you're no longer a resident of Texas, and that means that essentially you've vacated the office of notary, they need to know these things because it is vital to good record keeping and the public trust, really, that the commissioning official knows what's going on with their notaries and where they are and who's still working under this name and all of those details. And it's something I really encourage you to take to heart. I think it can get really tough to report changes when you have them, but it's another responsibility of office that it's so important to a notary to do. Of course, you always want to reject improper coercion. This is a challenge sometimes for notaries in certain situations, like a workplace situation. And sometimes the coercion is not even malice. It is that so few people really understand what you do and why you do it. They don't understand why you can't put your signature and seal on a blank notarial certificate so it can be filled in later. They don't understand why you can't take someone's acknowledgement over the telephone and then complete the document. They don't understand why they can't have the document signed the night before and present it to you the next day. That, I'm sure, is just a tiny little sample of the many, many times you've been asked to perform improperly. Some notaries suffer from the agony of just being compelled to do something they know is wrong. And if you are ever in that situation, I would just encourage you, no matter what you do and no matter what the stakes are, reject the coercion, because at the end of the day, that comes back on you. The minute you have completed a notarial certificate and signed and sealed it, you must answer for the facts to which you've certified and then the circumstances under which you did that. So, stand up for what you know is right, and always reject when you are being coerced to do something improper. That ties right in with refusing conflicts of interest. You always want to provide your services without discriminating. And this is really important. How many of you kind of cringe a little bit when you have to say no? I will raise my hand. I'm a pleaser. So this is a difficult thing for me to do, but it's really important as a notary to know when you really must refuse to notarize. That's another thing that preserves the integrity of the Notarial Act, helps keep you away from the lines of liability, and at the end of the day, it does so much for the office to just, and I mean the office of Notary Public, to just always notarize only when all the pieces are in place and there are no barriers and there are no problems. Sometimes you just have to say no, and you can do it simply, directly. Always be able to cite why. That's helpful to a signer, and stick to your guns, because you've probably been in situations where someone really argued with you about completing the Notarial Act. But I'm proud of all of you who were able to persevere and decline and end the situation. So that's just a little small sampling of standards of professional conduct, but they're very important ones. Working hard on understanding what the standards of notarial professional conduct are will go a long way toward reducing this liability that I keep mentioning to you. I think it's it's a tough thing, but it's a reality that all of you as notaries, every time you notarize, you have unlimited liability for that act that you've performed, every notarization. Again, I said if you've completed that notarial certificate, you're going to have to answer to the circumstances that surrounded that notarization, to any false information or incorrect information or problems stemming from that notarization that end up causing damage or harm to another party. And so just be very, very sure when you notarize that you are confident that all of the requirements are in place. Your employer can also be exposed to some of that liability, particularly when the notary is performing scope of employment notarizations. And it's a good idea to talk to your employer. I mentioned some of you notaries who may be pressured, more than once to notarize improperly. That's a really important piece of information for employers and others who put you in those situations to understand that there can be some shared liability if you were forced to do this because you were threatened with job security or some other really stressful pressure. Your surety bond. I hope that all of you realize this. It is a good thing to have. It protects the public. It does not offer you any protection. In fact, if there is a claim that is paid from your bond, you will owe the underwriting company what they paid out on that bond. And you will still be responsible for any damages that exceed the limits of the bond. It is a good vehicle, and as far as public policy is concerned, it shows that the public can be protected and have this recourse whenever a notarization causes loss. But it's not for you. If you want protection, you need to make sure that you explore having an errors and omissions insurance policy. It's just like any other professional who does high-level, detailed work, and they have a malpractice policy or an errors and omissions policy that will help them if there is some kind of mistake that leads to loss for another. Any of your companies who issued your bond or helped you get your bond probably either sell errors and omissions insurance, or they can point you in the right direction. So if you don't have it, think about the types of notarial acts you performed. Think about your unlimited liability, and explore making sure that you look into errors and omissions insurance. So I want to take this opportunity now to start talking about your authorized duties. And we're still talking about the what of notarization. Because, again, of the limited time, we're going to focus on the formalities of the two authorized duties that are the most requested, and that, of course, is oaths and affirmations and acknowledgements. A Texas notary is also authorized to perform proofs of written instruments, certify copies of non-recordable documents, take depositions, and issue protests. There are a lot of procedures attached to those as well, but I'm certainly going to share the details of performing these two specific notarial acts. And remember, this is a fundamentals course. The foundation for correct performance of these acts will apply to the correct performance of these other acts that we're not going to cover. Let's see. So, oaths and affirmations. They have the same legal effect. Both an oath and an affirmation compel truthfulness under penalties of perjury about a statement or promise. A statement made in a written document or somebody who's verbalizing this promise. The difference between an oath or affirmation that's readily recognizable is whether or not there's a reference to God. Under an oath, the oath taker is swearing to the set of facts, and they're doing so by invoking God. They're tying their conscience to that divine person. So you'll typically hear or see a reference such as, do you solemnly swear under penalties of perjury that X is true, so help you God? That's an oath. The only difference in an affirmation literally is the person who is making this pledge is binding their conscience to themselves. They're not invoking a deity. So an affirmation is simply that someone affirms that this promise that they're making is true, or that they will fulfill it, or that the contents of the document are true. Oaths and affirmations can be verbal only, or they can involve a document. So let's take a closer look at how those can differ. So oaths and affirmations that do not involve a document typically are for, the easiest example is an oath of office. There are probably other situations. Oh, another good one is the oath of a credible witness for satisfactory identification. We'll talk about that. How many of you perform a verbal ceremony when you notarize? Well, okay, those were shy hands. It's like, I think I do. Okay, so I want this. And you know what, I think the public doesn't expect it, and notaries don't often perform it. But one thing I do want to point out, and we'll talk a little more about verbal ceremonies, but you'll see in your notarial certificates, you're certifying that the individual actually made an acknowledgement to you, or they swore an oath to you. The verbal ceremony helps ensure that you have truly captured that, because notarization really isn't silent. You are having an ongoing interaction and conversation with the signer. And so, that's really important, that if you're not in the habit of performing a verbal ceremony, that you get into the habit. And we'll talk about that when we start looking at the steps for a notarial act. For no document, an oath or affirmation, typical, again, oath of office. Do you, John Doe, solemnly swear or affirm that you'll uphold the duties of the office to which you were elected, so help you God, if it's an oath? If it were merely an affirmation, the question would be, do you affirm to this promise? And there would be no reference to God. So when an oath or affirmation is required for a document presented for notarization, the principal signer, and throughout the presentation, I will refer to a principal signer. That's the individual who is the named individual who comes before you for the notarial act, and they're signing a document. For an oath or affirmation involving a document, this person comes before you to swear or affirm the truthfulness of statements made in the document. Another important characteristic of oaths or affirmations for a document is that must be signed in your presence. If you've ever executed a jurat for a document and the document was presented already signed, then you did not witness the signature as is required for this notarial act. So if this is a surprise to any of you, just remember moving forward, it's critically important that you do that. It is a fundamental requirement of this notarial act that it be signed in your presence. The verbal ceremony, if it's an oath, of course, you can see the two variations here. The one for the oath has the reference to God. The one for the affirmation doesn't. I hope this is helpful. I struggled with how to talk about certificates and give you a roadmap. I don't know, for brand new notaries, how often you really get the opportunity to talk about what you are certifying to when you fill out this certificate. I want to try to point out what the certificate is saying. First of all, if you know how to read a certificate, then you know what notarial act is being asked of you by the certificate language in the document. So a signer comes to you, they present the document for notarization. They know it needs to be notarized, A, because they were told to have it notarized, B, because in most cases, occasionally not, but most cases, there will be certificate language below the signature. So these are the certificate elements for oaths and affirmations on a document. The venue is the location of the notarization. That's where you are standing in Texas the day you notarize. It's not your county of residency. It's not any of the things that you would imagine. It is literally, geographically, where am I in Texas today? It's the state of Texas and the county where you are physically located. You see the orange where it says sworn to? That's your tip-off right there. This will be an oath affirmation, notarial act. The kind of pinky color, subscribed. And then look at the blue there, before me. There's a statement, subscribed before me. Remember I said that an oath affirmation requires that the document be signed in the presence of the notary? This is the standard language. And when you sign and seal this certificate, you're certifying that that document was signed in your presence. So always be sure that with this notarial act, you are witnessing that signature. Getting back to before me again, that indicates presence. And of course, we know that the golden rule of notarization is the personal appearance of the signer before you. And yes, we now have remote online notarization where the signer can appear through audio-video technology, but guess what? That is still the fundamental requirement of personal appearance. They are appearing in an authorized manner for those circumstances. For a document notarization that involves a paper document or an electronic document not online, that appearance always must be physical. So again, that's a huge fact to which you're certifying when you complete a notarial certificate. The exact date of notarization always goes in your certificate, that's the green. You will name the principal who you satisfactorily identified or who you knew through personal knowledge. The fact that you have put that person's name in there indicates that you identified them. Of course, we all know that's a fundamental requirement of notarization. You will put your official signature, the official seal, and the title of office. So those are the key components of a notarial certificate. And again, for an oath affirmation, you're looking for that language, sworn to or affirmed, subscribed before me. That's your tip-off. Another thing and I'll just mention it this once, I won't mention it again when we're talking about other certificates. I assume you know, and if you don't, we should talk about it, that if there's no notarial certificate on the document, that you cannot make the choice on behalf of the signer. Even if every brain cell is screaming at you, gosh, this is a contract and these generally take an acknowledgement. You are there to perform a ministerial function. So either the notarial act required should be already indicated on the document, and if it's not there, then the signer needs to indicate in some manner to you what notarial act should be performed. Generally, what I recommend and what most notary experts recommend is you simply tell the signer, these are the notarial acts that I'm authorized to perform. These are the characteristics and what you are certifying or what you're stating to me by performing these acts. And you can even show them correlating samples of the notarial certificates. Many signers will go ahead and make a choice at that point. And of course, you want to carefully record in your record book that you did have to walk through that process because the document was presented without a notarial certificate. But that's how you obtain guidance. If the signer can't make the choice themselves, no matter how much they implore you to help them, you can't. You've just provided as much help as you can provide. They can seek help from the relying parties, whoever drafted the document, whoever's receiving the document, an attorney if it rises to that level of needing legal consultation. But at the end of the day, you cannot act unless the act is evident to you. It's not something that you can choose. So it's important, we're talking here about your ability to recognize these notarial certificates and these notarial acts, but you still can't leverage that information to help a signer by telling them what you think belongs on the document. So let's talk about acknowledgements. Those are probably the most commonly requested notarial acts. You'll perform a lot of oaths and affirmations in your time, but a lot of documents are acknowledged. A signer may sign for himself as an acknowledgement. I knew it. I'm going to put these thumbs on a diet. I don't know my own strength. Okay, Acknowledgements. In an acknowledgement, a person is declaring or acknowledging signing a document voluntarily for its stated purposes and considerations. If you just think about the meaning of what I just said, you'll realize, oh gosh, everything that entails the agreement of the signer or between parties, or where there's some kind of contractual clause, or anything that involves the signer essentially accepting the terms and conditions stated in the document, that will generally be an acknowledgement. Remember, I really stressed to you that for an oath affirmation, the document has to be signed in your presence. Acknowledgements, not so much, because they can be already signed by the individual who's appearing for the notarization, or they can be signed in your presence. And I know that sounds odd, because I'm aware that there are notaries who think they have to literally witness every signature. For an acknowledgement, you don't, because they are simply acknowledging that that signature on this record, this document, is mine, and that I made it voluntarily for the purposes stated in the document. So whether or not it was made earlier by the signer or at the time that they're before you is immaterial to that acknowledgement. Now, if the document is signed before it comes to you for notarization, you do want to feel that you're being presented with the record that is essentially the original record that had that person's signature affixed directly to it. Another interesting thing about acknowledgements, and again, when I use terms like power of attorney, that'll feel very familiar to you. With an acknowledgement, a person can either sign for themselves in an individual capacity, or they can sign as a representative or agent for another party that gives them the authority to do that. So let's talk about that a little bit. Okay. In an individual capacity, of course, as I said, the principal signer comes before you and acknowledges having signed the document willingly for its stated purpose. In a representative capacity, the individual appearing before you is essentially doing the same thing, but they're signing the document on behalf of another party who gave them the authority to do that. The most common example I can think of is, again, a power of attorney, someone acting because they've been given the power by another person to sign for them. Another representative capacity signing involves, for instance, a corporate officer signing on behalf of the corporation. You're not responsible for verifying the representative capacity, and I want to be real clear about what I mean by verifying. Even if you're presented with some sort of evidence by the representative signer that they have the authority to act in this way, you have no authoritative way of knowing whether or not that, let's say it's a power of attorney, that thing could have been amended or rescinded earlier in the day. You would have no way of knowing that. So it's not your role to try to verify and authoritatively judge whether that's a valid power of attorney and that the person can act. It's reasonable for you, if this is your practice, to say, well, do you have a copy of it and you can observe it? But at the end of the day, you can't. You really take the individual's word that they have the authority that's claimed, and you proceed. And if there is a problem with the authority, that's something that the relying parties will work out on the other end. If you had to somehow absolutely verify the validity of every representative capacity that was claimed for notarization when a signer came before you, we would have a terrible logjam, because there really isn't a way to do that. So act with reasonable care, feel comfortable in proceeding. If there's some reason that you feel very strongly that perhaps there's fraud being committed, of course, you should decline the Notarial Act. But again, don't make yourself the judge and jury of whether or not this person has representative capacity. The verbal ceremony for an acknowledgement is the same, whether it's an individual capacity or a representative capacity. It's, you ask the individual, do you acknowledge signing this document? willingly for the purposes and considerations in it, and there are other verbal variations that essentially accomplish the same thing. So those are the fundamentals of acknowledgements. So let's look at the certificate elements. And we walked through the color coding, and you can, hopefully this is helping you see a roadmap. Sometimes, and I fell victim to this when I was a new notary. I think sometimes notaries get so concerned about what to write into the blanks, they're forgetting to read the statement in the notarial certificate. It's the totality of the statement plus what you write into the blanks in the certificate that is your certified statement about the facts of the Notarial Act. So always be sure that, again, you know how to read notarial certificates and that you understand what you're seeing here. I want to point out the orange. Remember on the oath affirmation, it said sworn to or subscribed before me, or it might say sworn to or affirmed before me. That indicates the oath affirmation. Here it says acknowledged before me. And so that's a powerful clue. Hey, this is an acknowledgement notarial act. Now this is called the short form of acknowledgement. There are uniform laws that provide standard wording that is frequently referred to as the short form for different types of notarial acts and particularly for the acknowledgement. But there are also longer forms of acknowledgement language that you will see. As long as the wording substantially reflects that an acknowledgement occurred and it enables you to put the facts of the notarization that are required in the notarial certificate, you don't have to slavishly adhere to specific notarial wording for the acknowledgement or the oath affirmation. But again, you want to know enough about reading and interpreting what you're seeing in the certificate to know that, hey, this is one of my authorized acts, it's the acknowledgement, and proceed from there. So this is the difference. Okay, acknowledge before me on this date. That's an individual acknowledgement by the name of the principal. I only highlighted the key differences when it's a representative capacity. You will state the same things, the same fundamentals of an acknowledgement having been performed, but you will name the representative who has been given authority to act. You'll also name his or her capacity or title. So, for example, let's say it's president of ABC Company. It's Joe President Joe Signer as president of ABC Company. That goes into the bright green. So it's very important when you take an acknowledgement in a representative capacity that you properly reflect that it is a representative capacity signing. You have to name the person who actually appeared, name the capacity, and name for whom or for what entity they are acting. That's very important. And again, as you're really nailing down how to look at a notarial certificate and know what's expected of you, that's going to be the key difference between an individual capacity acknowledgement and this one. So let's see. Yep. If I didn't have this to tell me, okay. So having gone through the what of notarization and why it's so important, and talked about some of the details of the authorized notarial acts that you would perform the most, I'd like to spend a little time here and talk about a really good, solid procedure for performing notarial acts that will help you get in your groove of performing them competently and confidently. And really, these are just the high points. As you're moving through this process of notarization, you're always remaining aware of things that are occurring, whether any of the elements that you thought were acceptable maybe are changing. A few minutes ago, you might have thought the signer was perfectly competent, but maybe they're not now, you're not so sure. My point is, these are steps in a process. But the entire process is an entire notarial act, and you're performing an act from beginning to end, and you're actively engaged in performing that act. from the moment the signer appears before you until the signer walks out the door with that document and you've completed the certificate and you've completed your record book entry. So those are the key procedures that we're going to walk through. I'm curious, how many of you kind of got this in your head? Like, do you have your own kind of methodology that you use to try to make sure you hit all the requirements? I'm seeing some nods out there. You know, for the newbies who kind of are not sure what you might do first when you're presented with a document, this can be really helpful to you. It can really help you get your feet under you in performing notarial acts. So, as I mentioned, golden rule of notarization required the personal appearance of the signer. All of my presentations used to say require the physical presence of the signer, except Texas and about 10 to 13 other states, because we have some new enactments that have happened, have authorized that personal appearance can be satisfied under certain circumstances for an online notarization when the signer is appearing by audio-video technology. So these blanket statements I've been making for years, no matter what, the signer has to personally and physically appear before you, is not necessarily true. But it is required of a Texas notary when you are, of course, the traditional notary under that traditional notary commission, and you're notarizing a paper document, you have to have the physical presence. And when you're notarizing an electronic document, but it's not an online appearance of the signer. Now, you've had the ability for a while now to notarize electronically. And electronic notarization for quite some time in the US has been authorized in a number of states. There are federal laws that say really it's okay to do. It's just been a slow adoption process. But always, until recently, even with an electronic notarization, the notary and the signer could not be remote from one another. They had to be in each other's physical presence. You were simply notarizing an electronic document. We have to really qualify that now because we have online notarization, and there is a different way of satisfying the personal appearance requirement than just physical presence. But I'm mostly, because this is a fundamentals course, I'm mostly thinking that most of you are performing paper notarizations. So I'll say physical presence, but just be aware that it can differ. But again, for paper document notarizations and electronic notarizations that are not performed online, no questions asked, always the physical presence of the signer. That's rule number one. Number two is you want to just scan the document presented to you, because you're looking for certain key things that will enable you to proceed with the notarization. And the first one is, do you feel you have a complete document? You do not want to perform a notarial act for a document that is not complete when it's presented to you, because there are certain things that you won't be able to do. If you don't have all the pages of the document, how do you know how many pages were in the document when you try to describe it in your record book? How do you know that maybe there wasn't another required notarization for another signer or something else in the document that may have affected your decision making and looking at that document if you don't have all the pages? One of the, it's really an innocent mistake that a signer will make in presenting a document to the notary. They'll only give the notary the signature page because, because they think that's the only page that the notary needs to be concerned with, when no, not at all. You guys have to have the whole thing. So it sounds like every one of you is perfectly aware of that. Of course, in examining the document, you want to review the notarial certificate, as we talked about. That's what tells you the duties that you are being asked to perform. Never forget to make sure that you are being asked to perform an authorized act. A lot of folks who create documents and they create the notary statement, they think a notary has amazing powers to certify anything, and they will pack that certificate with all of those things, and the next thing you know, if you just go along with that certificate and sign and seal it, you've certified to things that you absolutely are not authorized to certify to. And sometimes this can occur in ways that you might not expect. Like if you're performing a notarization for someone from another state and they have their document and their document was drawn up in another state, remember that notary laws differ from state to state. There are some acts that may be performed in some states that you can't perform. And that gets back to how critically important it is that you are comfortable with reading notarial certificates and knowing what you're seeing and what you would be certifying to if you were to complete that certificate. So that's another reason to scan the document. You want to see who is the principal signer, who is the individual who requires a notarization and who should be personally appearing before me. Is the document already signed? And of course that can only occur with an acknowledgement. But if it is already signed, you want to look at that signature. You want to feel confident that that was a signature applied directly to that document so that you have the original document. You want to make sure that that signature is not post-dated. It can't be dated after the date of the notarial act if it's already been signed. They may have signed it on the day of notarization and they would have that date on there, and as long as it's the same day as notarization, that's fine, or even earlier, because that would reflect when they signed it. But never perform an acknowledgement notarization where the document is presented already signed and the signature is dated after the date of notarization. You also want to examine the document to be sure that you can make an accurate description of it in your record book. So the next step is discuss your fees. You've examined the document, you know the notarial act that's required to be performed. And you know how many notarial acts you need to perform for the document. So, of course, fees are optional. You don't have to charge them. If you do intend to charge them, disclose the intent to charge fees before you perform the notarial act. It's the professional thing to do. And remember, in the spirit of the law that requires you to have a list of fees posted at your office, if you're outside of your office, I'd mention keep a little stack of fee lists handy. Make sure that you disclose your intent to charge fees if you will do that. Give the person a list of the fees and give them the opportunity to proceed with the notarization and agree to the fees or decline. But up front, before you proceed any further, is the time to do that. You have to do it now because you really don't know what your fees are until you've examined the document and you know what's required of you. This one's obvious, but don't charge fees above those specified in statute. That's a bad thing, and of course you would never do that. The most requested notarial acts, please make sure you go in and look at Government Code 406024 for the other authorized fees that you may charge. It was so lengthy and so detailed, I didn't want to overwhelm you with that, because really what's important is you're able to charge $6 for every signature for an acknowledgement or proof, and $6 for I believe it's every certificate for an acknowledgement or proof. And I think Robert Sumner's presentation has a comment about that. So remember what I'm saying about fees. Go and look at your government code and make sure that when you charge your fees and you're able to charge more than just the $6 because you have multiple signatures, that you are doing so appropriately and in accordance with statutes. That's very important. Good. Okay. So the next step is to identify the signer. Texas allows you to identify signers using your personal knowledge of the signer or satisfactory evidence of identification. I want to say a quick word about personal knowledge. It is not casual. It is actually a very high standard, and I really hope that all of you are very thoughtful before you decide that you will indicate that you personally knew the signer who came before you. I want to suggest that even people that you know anecdotally, even people you work with, if you don't interact with them on such a personal level that you have an unshakable doubt as to their identity, just ask them for an identification card, because you never know when someone is actually utilizing in a name that's really not their legal name. It's really not what's reflected on their identification card. It's just different than what you have in your head is their name. Always remember that personal knowledge is not the lowest standard. It's actually pretty much the highest standard. You really want to be absolutely sure you know who that individual is. You can also identify a signer if you don't personally know them by satisfactory evidence of identification. There's a couple of ways that a signer can try to evidence their identity to you. And this is for specifically paper document notarizations and electronic notarizations that are not performed online, because there is a different methodology for identifying signers who are appearing online. But for electronic notarization and paper notarization, the signer physically before you, they can present a current identification card or other document issued by the federal government or any state government that has the photograph and the signature of the acknowledging person. I put the note in there about the foreign passport because passports are acceptable, but that would be a U.S. passport. A foreign passport is only acceptable with respect to a deed or other instrument relating to a residential real estate transaction. So just be very mindful of that when you're dealing with passports. The other mode of satisfactory identification is the verbal oath of a credible witness who you personally know. So that you're kind of the connective tissue between the individual who needs identification and the credible witness. You know the credible witness knows the person. You're able to take their verbal oath as to who that individual is. Some states require actually a written affidavit about the credible witness. But in Texas, you're able to simply have that individual swear an oath as to the identity of the signer. Keep in mind that verbal oaths are authorized notarial acts. I'd like to suggest that when you take an oath for a credible witness, create a separate record book entry for that particular administration of an oath, because you've administered an oath to somebody else, and that is an official notarial act. You can make a separate record book entry for that. It can be tied to the underlying transactions record book entry by just making a note in the comments. Entries 4 and 5 are related, or something to that effect. But, never, I think sometimes notaries administer some verbal oaths and affirmations and they don't realize, well, wait a minute, that's an authorized notarial act and I'm supposed to record my notarial acts in my journal or my record book. So try to be mindful of that when you do that. All right, so at this point, I and other notary experts recommend that you create a record at this time in the notarial procedure. And yes, you haven't gone all the way through the notarial procedure, but what's so important about doing it now is that you haven't created that sense of ending that the layperson feels when a notary signs and seals a certificate. I think some folks are just eager to get about their day, and they don't mean to, but literally when you've completed that notarial certificate, they want to take their document and walk out the door. And they might, if you're distracted, if you're writing something else, you could easily let that signer get away before you've captured everything that you need for your record book entry. And of course, one of the most valuable pieces of evidence you can collect, even though it's not required in Texas, is the signature of that individual in your record book. So we recommend that you do the record book entry here because they're still waiting for you to complete all of your actions, and this is something that you're required by law to complete, and it's helpful to be sure that they're there to help you do that. You can create your records on a book, a computer, other storage device. I'd mentioned you can use a tangible record book or an electronic one. With an online notarization and for online notaries, there are very specific requirements for the way that they record online notarizations and how they're stored. So, I always have to give that little caveat. The fundamental requirement is there. Online notaries have to make a record as well, but there are some differences in how their product has to be able to perform. And of course, all of you probably know that a notary's records of notarial acts are public record. That's why it's so important that you are mindful of the things you are not allowed to put into a notarial record. You know, you're not allowed to put identifying numbers in there. You may have a record book that you've had for quite some time and that you've recorded these things, and then you get a public records request. Always, if you get a public records request and you have to issue a copy and you have sensitive personal information, always make sure you redact that information. The entry requirements are right here. I think we're going to have to wrap up really quickly, so I want you to look at Government Code 406014 and make sure that you are recording absolutely everything that you're supposed to record. The next step is the document execution and the verbal ceremony, which really, remember, for an oath affirmation, you literally have to witness the person signing the document. You have to review the signature just one more time if it's an acknowledgement and it was already signed. That's what I mean by document execution. It's the formalities surrounding the signing of the document. And then you perform the appropriate verbal ceremony for the notarial act that you are officiating for. And of course, for the oath affirmation, and try to look at the different color text. I tried to highlight the words associated with an oath and the words associated with an affirmation. Do you, John Doe, solemnly swear under penalties of perjury that the information contained in this document is true, so help you God? Or do you, John Doe, affirm under penalties of perjury that the information contained in this document is true? And then, of course, the wording for the acknowledgement. So let's see. I already mentioned refusing or stopping a notarization, so I won't go into detail here because we're going to have to wrap it up. But as I mentioned before, stick to your guns. Never be afraid to tell someone you just can't proceed with the notarial act. It's very important that you protect yourself and really protect the integrity of the transaction by doing that. Texas Administrative Code Section 8742 has a lengthy list of prohibited acts, and you also, of course, want to read all of your notary statutes and the administrative code. It lists of prohibited acts here that are the most common. I talked about choosing the notarial certificate because I think that's one that notaries accidentally back themselves into doing. So be very, very careful about that. And that is almost it. I want to thank you guys so much. I hope you've gotten a sense that the fundamentals of what you do are so essential and so important. It's an ancient office. You've been providing the assurances of notarization for years and years and years to relying parties. And even if it's just a school permission form, even if it's just a little small agreement that's not of great monetary value, or maybe it's for a mortgage that changes someone's life, every notarial act you perform matters. Those assurances that you provide can only be provided for you and so by you, and I want you to realize how very, very special and necessary and respected notaries should be. Be proud of what you do. Thank you.